but I'll take you through it, which is that the Californian jury finding that Meta and YouTube liable in this social media addiction trial, and they have awarded damages of $3 million. And as we were saying, it is important because there are a couple of thousand similar lawsuits ready and waiting to go, people and those teams watching these events, and they will now take heart, and perhaps we will see more of these cases in the coming weeks, because it is a critical case. It's all about the use of social media and any warnings or lack of warnings that were given to youngsters who then became addicted, with all of the consequences they laid out to the court. Chris, I gather the line has been re-established. Sorry, we lost you briefly, but I was trying to ask you what you made of the amount of damages, $3 million.
Yeah, it's not actually that significant, Matthew, if we look at the broader scale of things. It might be, well, life-changing for Kaylee in a very significant amount, but we have to look in the broader context here. So just yesterday, Meta was found to be was caught up in a case in New Mexico where they were fined something like $750 million. Even then, that was not that significant, because if we look at their revenue last year, they earned something like 200 billion. So the reality is that this is a relatively small amount for a company as large as Meta, which obviously spans the world and earns an awful lot through not just our engagement and our use, but also serving adverts against that as well.
It is interesting, because you were talking about the significance of this trial, because most of the legal issues in this case, namely that social media platforms are addictive to young users and intentionally designed to be so, are completely unprecedented. Those were the phrases used by the actual judge in this case several times, and that line jumps out, that the actual model, it was intentionally designed to be like this. That was the charge, which appears to have been upheld.
And there will be a lot of people watching who will agree with that in potential, because they have obviously been using these social media platforms now for almost 2 decades. If we look back at the history, there are individual design tweaks that are meant to grab our attention, meant to keep us on the platforms, anything from the very small red notifications that make it seem like you're missing out on something, to the infinite scroll that we start to see on social media in the last 5 or so years, popularized by lots of platforms, including TikTok. So the idea that you can't really complete a social network in any way, because there is always new content to be consumed. I think what is really interesting about this, Matthew, is that it effectively goes against a very long-standing rule and a sort of carve-out for social networks that has existed for the best part of now roughly 3 decades, which is this concept of Section 230, which is a sort of amendment to a long-standing Communications Act that has existed in the United States for nearly 100 years now, which effectively said that any web-based platform, and that word platform is important, wasn't liable for the consequences of what happened on those platforms. So really what this does is that puts that back into play a little bit by saying that actually these companies involved, they are causing addiction and mental health problems for their users.
Stay with me, because I'll return to you in a moment or two, but I wanted to bring into the conversation the entertainment lawyer, Trey Lovell. And Trey, welcome here to the programme. Your reaction to what we're hearing coming out of this court in LA?
Yeah, it's going to be very interesting. What happens in this case, as your previous guest said, it's a bellwether case. It's going to really set the trail for what's going to happen down the road in terms of all the other litigations that have been filed and are in the pipeline. And it's going to drastically change how social media works.
Kaylee, in her evidence, explained to the court she began using YouTube at the age of 6 and Instagram at the age of 9. Now, Meta had claimed to prohibit under 13s from any of its platforms, while YouTube offered different versions of its platforms for children like YouTube Kids. It seems, given the verdict we now know, that those sorts of defences just didn't fly.
No, not at all. I mean, even though there was testimony to that effect, there are other internal documents that suggested otherwise. Obviously, they were able to prove that there was a harm to her and a substantial injury related to the social media use. So they were able to challenge that and show that it either wasn't working or didn't apply in this case.
Let me ask you a question that I posed a moment or two ago, because it is really important, because the judge referenced it, how the social media platforms are intentionally designed to actually operate like this, and therefore, I suppose, the consequences that we saw brought to this case. That has a huge potential, doesn't it, in terms of presumably those companies now have to adapt and change.
Yes, it does, because one of the key issues here was whether or not the conduct was prohibited, or it was subject to immunity through Section 230, which pretty much immunizes Meta and the social media platforms for the content on their sites by other people. And thus they're saying, hey, we're not responsible for the content, we're immune. And the issue in the case was whether or not was this content that would have fallen under Section 230, where they couldn't have gone after the media companies, or was it a product? And this would fall under product liability laws, personal injury type things, and completely transform that. So obviously, the judge found the latter, and that's going to be a huge issue, not only on appeal, but moving forward in terms of how future complaints are drafted, the pleadings, and the litigations proceed.
We can see little huddles of people outside of the courthouse that have perhaps followed this case or part of this case, and we'll get reaction in the next few minutes, because we've been seeing the pictures of the microphones all set up. So at some stage, there it is, and that huddle to the left, the top left of your screen, but you can see the microphones ready for the formal responses, and as soon as anybody approaches those microphones, we will carry that. But in terms of this case, how difficult was it to actually bring a case like this and to bring it successfully?
It was very difficult. There were a lot of hurdles that the plaintiffs had. First, typically, any lawsuits against social media that are based on content have been dismissed and are prohibited because Congress essentially immunizes them based on third-party content. So that was the first hurdle that the companies certainly try to get out of. Then once you have that, now we have to look at the plaintiff. Was she really injured, suffering emotional stress and the harm? And even more importantly, if so, was that substantially related to the social media interactions? And there was a lot of evidence that said, hey, if she was hurt, it was before she started using social media, from things that happened within her household, within her childhood, and it was unrelated to anything that Meta did. So you had a number of hurdles. First, like getting by the immunity defense, showing it's a product for the very first time in history, and or as opposed to content. Then, was the plaintiff actually harmed? And if so, was Meta a substantial factor in what were the damages? So there was a lot of hurdles in this case, and why it's a novel case and so important, because even though this has merit in and of itself, this triggers, what's going to happen with those other 1,600 cases that have been filed and many more that will come thereafter.
I'll come to those other cases in a moment, but it's been a fascinating trial in some of the evidence and the exchanges, because the head of Instagram, Adam Mosseri, testified in the court that he thought even 16 hours of Instagram a day did not strike him as an addiction. He phrased it as problematic, and clearly the court has not accepted that. And Mark Zuckerberg, he was giving evidence and was cross-examined, became frustrated at different points. It has been fascinating to see these tech chiefs being questioned and put under real pressure to answer some of these basic questions.
Yeah, they essentially had to testify because they had these internal documents that they had to explain, because on the face, they didn't look good for the social media companies. So Zuckerberg needed to come in there and explain them and interpret them in a way that would be in favor of Meta, show that they were making efforts, that it wasn't, these design features that were hurting people. And then at that point, then it goes to the jury, which as it did. So, Zuckerberg, I don't want to say he was dragged into it, but he needed to be the one to explain this away. And when you have internal documents that at the time they're prepared, the last thing is on anybody's mind is they're going to be exhibit A or B to a lawsuit. A lot of vulnerability is there. And now these things surface, and then you have to get around them and explain the meaning, and that can be a big challenge.
Trey, stay there. I'll come back to you in a moment, but I want to go back to Chris Stokell-Walker, the technology journalist who we talked to a short while ago. And Chris, just let's go back to the issue of all those other cases now in the pipeline. What sort of number, first of all, are we talking about?
Up to 2,000, and that sounds like an awful lot, but there are some that are coming down the pipeline in the coming months. So we do have another trial scheduled in July in Los Angeles, so in the same sort of area as this, and there's a separate one that we understand will be brought in the summer in California by a bunch of school districts and also several states, because this is not just the individuals that are lodging this with the help of lawyers. There are an increasing number of organizations and state level actions to try and bring social media to heel here.
It's really interesting because I read out line by line some of what the jury has been saying. I've got more of it in front of me, so I will read it out as we continue to watch the pictures of the microphones in case any of the lawyers and the legal teams come to address the assembled press. But it's interesting because the jury answered yes on every question asked of them in this negligence and harm case, saying Meta and Google were negligent and should have warned users about the dangers to minors. So very interesting what they have decided. They found that Meta to be 70% responsible for the plaintiff's harm and YouTube were 30% to blame. And I've already mentioned the amount of money, $3 million the jury has set aside. But would you expect those tech giants to appeal?
Yeah, well, actually, I understand, Matthew, that we've had a statement in from a Meta spokesperson that says we respectfully disagree with the verdict and are evaluating our legal options. That's just come across one of the news wires. I'm sure that's also with yours. Just to correct something that I said earlier as well, I think I said that there was a New Mexico trial that was finding Meta liable for $750 million of damages. It was 375, but nonetheless, I think the numbers that we're talking about here, 3 million in this case, 375 million in the previous case, they are relatively small fry for these companies, but it is still that precedent that we need to come back to that is quite so important here. Obviously, that I think is why we're hearing the Meta spokesperson saying that they disagree with it and they potentially plan to appeal, or at least they are reviewing their options, because if they are found liable and this does go down as such, then that becomes, I think, a bigger problem for them with all of the stuff that is still to come.
Let's go back to the lawyer, Trey Lovell, who's with us, responding, reacting as all of these lines become public. And Trey, it seems to suggest there's no confirmation, but it sort of seems by them saying they're evaluating their legal options, they respectfully disagree with the verdict, that perhaps we might see an appeal. If that was to be the case, does that presumably delay the 2,000 or so other cases that we were talking about there, about being in the pipeline?
No, most likely those cases will proceed. It's just going to be determined how fast the appellate process goes in this. But no, those cases will proceed. But the appeal is going to be huge because there are some serious legal issues. You know, whether or not Section 230 applies, which is the immunity statute, whether or not there was enough evidence to find that Meta was substantially the cause of the plaintiff's injuries. Whether or not the algorithms and the platforms were product features as opposed to just hosting content. Those are going to be big appellate issues, and a reversal on any one of those will make a huge difference. So, as I said, this is the test case, and that's really the relevance of this.